Hello, my name is Crystal Dahl, and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar. For those of you that are new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality, specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms, and have been connecting clients with carefully qualified business legal expertise in over 250 markets around the world since 1990. Meritas Capability Webinars are regularly presented by Meritas members. Before we get started, I'd like to quickly go over a few housekeeping items. Meritas offers the ability to listen to our webinars through your computer speakers. If at any time you have any difficulty hearing the presentation, you may call into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician, or you can use your questions feature. Since you will be muted, if you have a question, please ask via that questions module. You may need to expand the section by clicking on the gray bar that says questions to actually type a question into the field. Lastly, in the next few days, I will distribute a copy of this presentation, a recording of the webinar, as well as everybody's contact details. Joining me today is Thomas Felsberg, the founding partner of Meritas affiliate Felsberg Advogados in Sao Paulo, Brazil. We also have Felipe, I'm sorry, I might mispronounce your name, Bonzenso, a partner at CALS, specializing in aviation law, particularly in regulatory matters and aircraft finance, with extensive knowledge on the Brazilian market and the country's legal framework. We also have Jaime Cubillos, a partner at the Meritas affiliate Pace Herrera Ruiz in Colombia. His practice centers on corporate transactions with a focus on domestic and cross-border mergers and acquisitions, representing acquirers and targets in cross-border acquisitions, auctions, dispositions, and joint ventures. We also have Benjamin Grabe from the Meritas affiliate in Santiago, Chile. He leads the insolvency and bankruptcy area and has experience representing creditors, debtors, and interested parties on judicial proceedings of bankruptcy and insolvencies and in commercial arbitration. Flores Aikin comes from Alvarez and Marcel in Mexico City, Mexico. Flores is the managing director and has 18 years of financial restructuring and corporate finance experience. Last but certainly not least, we have Melissa Pena joining us from the U.S. at the Meritas affiliate Norris McLaughlin in New Jersey. Her practice concentrates on commercial litigation and bankruptcy and creditors' rights. I'm sorry if I mispronounced anybody's name. With that, Thomas, are you ready to get us started?
Yeah, sure. Thank you very much, Crystal. Good afternoon to everybody. And for those who are in the morning or at night, a good day or a good night, whatever. Thank you for joining us. And I also want to thank our panelists, this brilliant group of panelists, which we have today. Felipe had some technological problems, so we may not see him for a while. But he will be joining us by audio, so we will hear him, and his comments will also come through. Okay, yes. Basically, I would like to start our webinar by asking Flores to give us an idea, or more than an idea, to give his take on the economic and financial situation of airlines in this era of pandemic of the COVID-19 issues. How are they faring? What is their situation right now? It's a tall order, 3 minutes, but
I'm ready, Thomas, and good afternoon, evening, morning to everyone. Listen, just to get right into it, I'm going to try and set the stage on the airline industry with citing some commentary from Delta Airlines Q2 earnings call last week. There's no better way to get a real handle on the situation than by hearing some facts from one of the world's largest carriers. Delta reported demand for air travel declined significantly in the June quarter as a result of COVID-19, with in-plane passengers down 93% year over year. Delta's adjusted operating revenue of $1.2 billion for the quarter was down 91% versus the same quarter a year ago. Passenger revenues declined 94% on 85% lower capacity. Non-ticketed revenue declined 65% as cargo, MRO, and loyalty declined at a slightly lower rate than ticket revenue. How has Delta been handling this quarter? They've had to do a number of remedial efforts. They've made significant efforts to reduce their cash burn. They've amended credit facilities to replace all fixed charge coverage ratio covenants with liquidity-based covenants. They've extended maturities of $1.3 billion of borrowings under revolving credit facilities from 2021 to 2022. They've aggressively managed their costs through lower capacity, reduced fuel expenses, cost initiatives, including reduced work schedules and voluntary employee leave of absences, parking aircraft, consolidating facilities, and eliminating nearly all discretionary spend. How does this sort of translate into our topic of today, which is Latin American Airlines? During the June quarter, the company recorded a write-down of $1.1 billion in its investment in LATAM Airlines and a $770 million write-down in its investment in Aeromexico, following both of their company's financial losses and their separate Chapter 11 bankruptcy filings. Delta also wrote down an investment in Virgin Atlantic, resulting in a $200 million charge. In the middle of all this quarter, Delta raised $15 billion in financing transactions at a blended average interest rate of 5.5%. This included some unsecured loans under the CARES Act, which was a government bailout. Delta ended the quarter with $15 billion in cash. So if they hadn't raised $15 billion in financing, it would basically be out of cash at the end of this quarter. So it's pretty, with the Delta example, you can see how bleak it is out there. You know, just to wrap up the observations, of the $15 billion, Delta obtained $5.4 billion of grant funds and unsecured loans through the CARES Act. So governments both in the US and Europe, for that matter, have been providing assistance to the airlines. But Thomas, I think we should hear from the other panelists about how government assistance is working out in the rest of Latin America.
Thank you very much, Flores. Let me go to the other panelists and ask them what governmental assistance has been granted or is being planned to be granted to the airlines. So let me start with Benjamin.
Thank you, Thomas. Actually, there's nothing concrete so far, and I think initially there were some talks about the importance of keeping governmental aid, but at the end, politically, it is very difficult to go to that path, considering that probably the main discussion nowadays, yesterday and today, is about whether the people can take pension funds for having a living, for living, for paying the bills. So introducing this discussion about political aid to an airline and to their shareholders, it's politically complicated, although in the LATAM's filing in the Chapter 11, they consider a tranche for the governmental assistance, but we have no news so far about that.
Thank you. Jaime, how is it in Colombia?
In Colombia, we have a very similar situation to what Benjamin just described in Chile. Financial assistance programs by the government have initially targeted small companies and have also focused on payroll payments. A few days ago, the government rolled out a special program for bigger companies in Colombia, where the government basically serves as a guarantor for loans taken out by the bigger companies. It is still pending to initiate. But specifically regarding airlines in Colombia, there has been substantial discussions regarding whether the government should provide any specific aid to Avianca. And as Benjamin mentioned, in Chile, it is very similar in Colombia. It becomes a political issue on whether the government should be aiding an airline that operates in Colombia, but is headquartered in a foreign jurisdiction and operates in other jurisdictions as well, of course. But specifically in a country where smaller companies and the population in general are suffering because of the pandemic, it's going to be a very hard decision for the government to support a big company. However, the government did issue a decree where whoever reads it believes it's aimed at a potential program for Avianca, where the government is allowed to invest in capital or equity or debt instruments in companies that are critical for the Colombian economy. And basically, the decree specifies that the investment can be made even to the extent that the government believes that the return will be negative, that the investment will be made at a loss, which generates, it's controversial in Colombia, but it's, I believe, clear to the public that this is aiming at Avianca. However, the government has not come out with a specific aid for the company. But this is something that's in the middle of public debate.
That's a very interesting issue, which has been discussed in several places, including the World Bank and the IMF and so on. And the concept here is to make these loans, these assistance loans, conditional upon the restructuring of the company so that it will generate a sufficient cash flow in the future to pay back, or some equity valuation which will allow the government to recover whatever funds are injected in the companies. But a very, very important point you mentioned, Jaime. Let me ask Felipe a little bit about Brazil, and then we go to Melissa to give us the real solutions in the US, right? Felipe, how is government assistance viewed here in Brazil?
So hello to everybody. In Brazil, there is still a lot of debates. What just hit the news today is that there is a potential transaction between Azul and LATAM, which are two major carriers here, because honestly, the government package for support for the airlines has been on the discussion board for a couple of months now without any success, mainly for the reasons of what sort of guarantee would be provided by the airlines. So in the interim, the airlines are trying to find other ways to get a better cash position, to renegotiate its lease agreements and reduce its costs. And it's also important to clarify that Brazil has taken some measures in order to protect the airlines, such as to allow reimbursement of airline tickets and ensure a minimum route network that should work. But so far, the really expected support package from the government, which is something about 3 billion reais, has not been approved yet. It's still in the discussion with BNDES, with the Developing National Bank. And we should see further developments in that regard in the near future.
Thank you very much, Felipe. Let us go now to Melissa. So she could tell us what is the views in the US, but mainly the experience with Chapter 11 restructurings and US filings. And we know that some of the Latin American airlines have filed in New York, LATAM, Aeromac, Mexico. And I think also I'm not sure about Avianca, but Jaime will clarify this. But Melissa, why don't you give us a description of the U.S. Chapter 11 in respect to airlines?
Sure. So unlike other jurisdictions, the Chapter 11 procedure in the United States permits a company to reorganize its business, meaning continue to operate during the Chapter 11 process. It's not your straight liquidation. What occurs is that a company files and existing management stays in place. The company continues to retain its assets and operate with business as usual under the auspices of the bankruptcy court, of course. The general steps of a Chapter 11 case is for a voluntary petition to be filed with the bankruptcy court. And immediately upon the filing of the bankruptcy petition, an automatic stay goes into effect. And that automatic stay prevents creditors from reaching the debtor's assets. So lessors or lenders with respect to aircraft equipment are unable to basically take back their collateral or their aircrafts at that time. The debtor then generally avails itself of various protections set forth in the bankruptcy code in order to stabilize its operations. And then ultimately it proposes what we call as a plan of reorganization, which will dictate what creditors and equity interest holders will receive. Once that plan is confirmed, the debtor emerges from bankruptcy as a going concern. So we see a lot of airline companies filing right now in the Southern District of New York. As Thomas pointed out, LATAM, Avianca has filed in New York, as well as Aeromexico. And the reason, there's a lot of reasons that they're finding this to be a favorable forum. As an initial matter, from a jurisdictional standpoint, all they need to establish to avail themselves of the United States Bankruptcy Court is that there is some property in the United States. And the existence of a retainer to a United States law firm is sufficient for them to avail themselves. In addition to that, they find that the automatic stay is very favorable because it has extra jurisdictional reach. So I think some of the other speakers today will talk about how the automatic stay is being recognized in other jurisdictions. So they're able to file in the United States and hold back foreign creditors as well as US creditors. And then also there is some favorable provisions of the bankruptcy code that help them restructure their business. I'll talk about a couple of those right now. One of them is a debtor in a Chapter 11 case is able to obtain what we call as debtor in possession financing. And that's simply a loan that's provided to the Chapter 11 debtor in the context of the Chapter 11 case to allow it to stabilize its operations. And it's obviously needed for the airline industries. We've heard from Flores a little bit about what they're facing. In addition to that, the infusion of capital encourages other suppliers and vendors to continue to do business with the aircraft company because they see that there's the ability to get paid. Lenders who are providing what we call debtor in possession financing in the United States, they're often provided various protections. It can be provided what we call a priming lien, and that's a lien that goes senior and above an existing secured creditor. They'd obviously have to meet certain requirements under the bankruptcy code to obtain that. And they also can obtain what we call as super priority administrative status, which would give them the highest priority claim in a Chapter 11 bankruptcy case. Already in the Southern District, LATAM has filed an application for a debtor in possession financing loan. They received about $900 million in the form from existing shareholders, and then an additional tranche of $1.3 billion from Oaktree Capital Partners. As of now, Aeromexico and Avianca have not filed what we call our DIP applications for loans. The other thing that's really favorable under the United States Code for these airline companies is there's an ability under the code to reject aircraft leases as well as abandoned aircraft equipment and airplanes that they find are not economically feasible. Under Section 365 of the Bankruptcy Code, a debtor can choose to reject an aircraft lease. And the standard is very deferential to the debtor. It's a business judgment standard. So basically, it's sufficient for the debtor to come into court and say, we're no longer using this aircraft, and the requirement to continue to make lease payments on it would be financially burdensome for the estate, and it will be approved. And we're seeing that in the Avianca case and the LATAM case, there have already been orders entered rejecting aircraft leases, and the provisions of those orders are very favorable to the debtor. They have allowed the debtor to return the aircraft and the equipment in an as-is condition. They've also allowed the debtor to return it in a location of the debtor's selection, which could be very expensive for the other counterparty to the lease. And they specifically state that the debtor will provide insurance and storage fees for only 15 days from the entry of the order. And thereafter, if the lessor does not pick up the equipment, they have to start paying for the insurance and the maintenance fees to the extent that the debtor can even file a motion to compel the payment. And then what we're also seeing is, aside from those orders that have been entered, various companies, aircraft companies, as well as lenders in the aircraft arena are entering into stipulations with the debtors. And those stipulations are basically providing that the debtors will maintain storage and insurance for the aircrafts during this interim period while they're deciding whether or not they're going to reject the lease or abandon the aircraft. And then they will provide the lessor or lender with 15 days notice of rejection. But these stipulations are a little bit more favorable than what's been entered into the court, because they're requiring the debtor to return the aircraft in a location that's specified in the contract, or a mutually agreeable location that both counterparties and the debtor will agree upon. But I think that's really why we're seeing a lot of filings in the United States, because of these protections and the ability to stabilize their operations under these provisions of the code.
Thank you very much, Melissa. Let me ask for our speakers here to give us an idea what happens in their respective countries, whether these orders from the U.S. Bankruptcy Court will be recognized in their countries, and how this is playing out. Let me start with Flores in Mexico, and then we ask the other speakers to intervene.
Sure. Thanks, Thomas. I'll put on my lawyer's hat, which is a kind of tiny hat. But you know what Melissa mentioned in terms of the reach of the protection, you know, it's going to come in, I think, pretty nicely into Mexico, because I'll mention what was one of the first day motions that Aeromexico filed, and it's the motion of the debtors for entry of an order confirming the statutory protections of the bankruptcy code. And the relief includes that non-debtor parties to unexpired leases and executory contracts with the debtors will continue to perform and will not unilaterally terminate their contracts. The creditors do not seize the debtor's assets, impose liens, or take any other action in violation of the automatic stay. Foreign government authorities do not deny, revoke, or suspend any licenses or permits solely because debtors are in Chapter 11. And this would also spare the debtors from the burden of commencing adversary proceedings to enforce the protections automatically provided by the bankruptcy code. This first day motion for Aeromexico filed on June 30th, entered on July 1st. The same motion was filed by LATAM and Avianca, cited in the motion filed by Aeromexico. So it appears that at least, you know, on paper, it's going to be pretty good enforcement within the country of Mexico, given these protections in favor of the debtors. I would just simply add, as an aside, there's already been one vendor reclamation claim filed by Goodrich for approximately $600,000 of tires that were delivered to Aeromexico in Mexico City within 40 days of the filing. So from a practicality matter, we'll see how these types of things play out in an international scenario. There could be many reclamation claims, and Aeromexico may or may not have the need for these tires and or the cash to address these types of claims. So I think we're in the early grounds of seeing exactly the practicality of it, but I think from a more technical legal perspective, it looks pretty favorable for Aeromexico to enjoy some of these protections of the bankruptcy code in the country of Mexico.
Thank you. Benjamin, please.
Yeah, we have exciting news from Chile, because everything is happening right now with LATAM. We have, since 2013, we have the Uncitral model rules in our law. So they were incorporated like 7 years ago. but we haven't applied them so far. So this is the very first time where we have the recognition of foreign insolvency procedures applied in Chile. And just look at the dates and how fast this happened. On 25th, 26th of May, LATAM filed its Chapter 11 in New York, in the Southern District. In the 1st of June, they filed the recognition application in the Chilean court. 3 days later, the 4th of June, the Santiago Tribunal issued the recognition of foreign insolvency proceeding. In the middle of a pandemic, I think it worked at least fast. 3 questions are arising from this recognition. And these questions probably will be clearer with this process. First is, what procedure should we follow? At the end, it was a very fast-track procedure, and it was according to the Uncitral rules that we have to say that it has a language that is not as that usual for the Chilean culture. But we are, it seems, applying very fast, at least. The second issue is how does this recognition works, and what are their effects, and especially considering that the recognition of the foreign procedure does not prevent to initiate an insolvency procedure in Chile, and it is expressly allowed the existence of parallel procedures in each country. So how this will play is very interesting, and what I can tell you so far, as I mentioned, that the court in Santiago issued a recognition order, and they agreed and they acceded to the recognition, but right now it is being contested by 3 stakeholders or 3 parties. One is a shareholder of the company, a minority shareholder that has a litigation against the company. They have this litigation currently in the Supreme Court, and they file an opposition and an appeal against the decision of the court, saying that they have really an interest on this issue. The court finally said that they should not be granted as a party in the procedure because they don't have the interest, so they will follow up or they will continue with an appeal. Then a second party that is opposing to the order is a lawyer, of course, that has tickets, Santiago to Sao Paulo. So he said that he has an interest in this file because he has these tickets that were canceled, and he's, making some points before the court, saying that this is a procedure in which the Chapter 11 in the US should not have been recognized because it affects public order, which is one of the exceptions that where Uncitral model law allows not to recognize the foreign procedures. Secondly, it says he says that there's an reciprocity rules, and that the US has not shown that they apply our insolvency procedures in the same way that we are doing it. And thirdly, is that LATAM has not its main place of business in New York. And that's probably the most interesting aspect of this discussion. Where is the real place of interest of LATAM? The third party that opposed to the recognition is the State Defense Council, the Consejo de Defensa del Estado, which is the most prestigious institution that defends the state public order rights. So the state is a party in this file, and more than opposed to the order of recognition, the state is questioning the real place of interest of LATAM, because so far probably all the people identify LATAM like a national champion based in Chile, So they are wondering why they are filing this Chapter 11 in New York in the Southern District. LATAM says that mainly they have some stock or ADRs issued in New York, that they have bondholders in New York, financing in New York, and that kind of arguments. The judge finally rejected in first instance the oppositions. Now they will go to the Court of Appeal, but in relation to the state intervention, the judge asked the company to provide evidence of its real place of interest in New York. So the company has like 15 days that are counting to provide more evidence about that. Basically, the judge said that essentially the recognition of a principal foreign insolvency procedure is can be modified if there are new facts to be provided. So it's not a final decision. So they asked the company to provide more information, more proof about their real place of interest. Obviously, politically, it is difficult to revert or to revoke that decision, but it is interesting what it is happening right now.
Thank you, Benjamin. Very interesting. Let us hear Jaime, and then perhaps Melissa could explain us a little bit the difference between a main proceeding and an ancillary proceeding under the U.S. bankruptcy law. But let's first hear Colombia, and then we go to Melissa.
Right. So in Colombia, it's interesting to run the parallel with Chile regarding LATAM Airlines, but also to run the parallel with what's happening with Avianca, where there's a different strategy in the insolvency filings in Colombia. So first of all, again, in Colombia, in 2006, an insolvency regime based on the Uncitral rules was also adopted. That was 2006, and there have been around 4 or 5 cases of cross-border insolvency prior to the pandemic. One of them was a big oil and gas company, which had its operations in Colombia, and its, let's say, main place of business was declared to be in Canada, where it was publicly traded. And that was a very controversial case. But now with the airlines, in LATAM, LATAM decided to request for a recognition of the bankruptcy under U.S. federal laws. And the result of that recognition, similar to what Benjamin was explaining in Chile, would be to cooperate with the main bankruptcy proceeding in the U.S. and basically to follow that process and orders from the U.S. and declare a general stay in Colombia of executory proceedings. In Colombia, the LATAM request was filed on June 4th, and the order was issued in June 12th. So that was a few more days than in Chile. It was not appealed, and there was also a discussion, and this discussion we had with LATAM, and we have not had yet with Avianca, because Avianca has not requested the same recognition as LATAM. So in LATAM, the company, the debtor, argued that even though that there are substantial operations in Colombia, in the U.S., they argued that most of the revenue is denominated in U.S. dollars, that their main financing facilities are subject to New York law or to U.S. state law, and several others arguing that the U.S. would be the main proceeding regarding cross-border insolvency that should be followed in Colombia, And the judge agreed and ordered the recognition, ordered the general stay of executory proceedings, and I believe there has been no appeals. With Avianca, it may be different because similar to what you have in Chile with LAN, Avianca has for many years publicized as a Colombian airline in Colombia, even though it's for other reasons, including tax purposes, its main office is in Panama. But Avianca also filed for bankruptcy in the US, but it has not requested recognition of the bankruptcy proceeding under cross-border rules in Colombia. So it's two different strategies. And the question in Colombia would be, and what we believe is happening is that Avianca is monitoring executory proceedings against the company. And if executory proceedings are initiated, Avianca will probably also request for the recognition of the bankruptcy proceeding in the US. And regarding, let's say, potential major collection proceedings from outside of Colombia, I believe the bet would be that the recognition of foreign judgments or foreign tribunal decisions, arbitration decisions, would probably take between 12 to 24 months to be recognized and executed upon in Colombia. So it's interesting to see that LATAM did file a request for recognition and received it a week after. Avianca has not yet. So that's the case in Colombia.
Thank you very much, Jaime. Let me ask you how this plays out, because in the US you have the main proceeding and the ancillary proceedings, and then you have a case like Avianca, like LATAM, and also a case like Avianca, where certainly the COMI lies in Chile and in Colombia respectively. But how does US law and the US courts deal with that? Would that have an impact in the Chapter 11 proceeding? The fact that it could recognize that the COMI, the center of main interest of the company, lies elsewhere, or does it not affect in any way?
I don't think it's going to impact the Chapter 11 proceeding as it is now with respect to these airline companies. But on the converse, if there is a foreign filing, for example, an airline company files in another jurisdiction, whether the United States recognizes that filing will depend on whether they determine it is a main proceeding or a non-main proceeding. So, for example, if an airline company were to file in another country, if they filed in a country where they have their center of their business operations, the US courts would recognize it, and the US courts would have the automatic stay that I discussed earlier go into effect immediately. Where if it was considered a non-main proceeding, if it was filed in a foreign country where they have some business operations, but it's not their center, then the US courts would not immediately apply the automatic stay. To the contrary, somebody would have to file an application to seek imposition of the automatic stay and show why it would have an impact on what we call in the United States a Chapter 15 proceeding. But as far as the Chapter 11 proceeding proceeds, it will proceed under Chapter 11 of the code.
Let me ask Felipe, what about Brazil? Do we recognize the US Chapter 11 filing? And what are the problems, considering that if this recognition is not permitted, what are the consequences of a US filing in Brazil?
Thomas, you are the truly authority and expert in that subject in Brazil, but I will try. Brazil does not recognize the Uncitral model law yet. The treaty is not enforceable, has not been ratified. So although for airline insolvencies, it is the first time that we have a Brazilian airline, which is STAM, part of the LATAM group, applying for bankruptcy protection Chapter 11 in the US, which has happened recently. This brings a lot of discussions in relation to the jurisdiction, indeed, since all the decisions are not automatically recognized in Brazil. But it will be interesting to see how it plays, because the courts in New York, they feel like they do have the full jurisdiction and authority to rule over the Chapter 11 and the bankruptcy protection of this Brazilian airline, while on the other hand, creditors could try to seek protection in Brazil as well, since Brazilian law determines that for a Brazilian headquartered and incorporated company such as STAM, the Brazilian courts should have exclusive jurisdiction. But we don't have any precedents in relation to that discussion, meaning creditors or other third parties interested in the airline reorganization plan going to courts in Brazil trying to affirm the Brazilian jurisdiction. So what I see is that if there is a decision by New York courts which needs to be enforced in Brazil, that should be enforced through a homologation process with the Superior Court of Justice, which should take anywhere from 6 months to 1 year.
Thank you, Philippe. And let me just follow up with a question which is very much in the minds of everybody. And then perhaps, I mean, there are several questions here, but I would like you to give a quick explanation of the Cape Town Convention and the Aircraft Protocol, which applies to it. Generally, if there is an airline insolvency, what happens is that the lessors want to get back their aircraft very quickly because they have a market where they could place it again. Now, in the current pandemic situation, the lessors don't want the aircraft back because then they have to, pay the parking, insurance, maintenance, whatever other expenses there are, and probably will have great difficulty in placing these aircraft in other airlines. So we have all of a sudden we have this aircraft protocol and the Cape Town Convention. How does it play out in this current scenario? Well, what was intended and what is really happening in practice here in Brazil? Felipe, could you just follow up with this question?
So Cape Town Convention, which was signed in 2001 and has been ratified in Brazil only in 2013, we had the opportunity to discuss it more thoroughly through the Avianca Brazil reorganization case. And the main concept under Cape Town Convention was to replicate Section 1110 of the US Bankruptcy Code in a global scale. So prior to this pandemic, all the discussions were, should a court or should the authorities in a said country respect the declaration made by the country in relation to the stay period, the applicable stay, which for instance, Brazil made a declaration saying that it would be 30 days. And in the Avianca case, due to all the discussions in courts, this ended up being a 120 days period. Unfortunately, what I see in relation to Cape Town is Cape Town, for instance, it does not supersede these provisions of the bankruptcy code in the US, because the declarations made by US is in line with the stay period that is under the bankruptcy code. So in Brazil, where you have conflicting provisions between Cape Town Convention saying 30 days, Brazilian law saying no stay period whatsoever, and courts extending into 120 days, it is truly now difficult and unpredictable, honestly, because lessors very few lessors are willing to take aircraft back. I still believe that all the airlines and lessors, they are still on the renegotiations and trying to settle amicable solutions for the aircraft, whether it's a lease extension or so. And Cape Town should become more relevant in the near future if all the negotiations with the airline fail, and then with the slow market recovery, it might be in the interest of lessors to repossess aircraft. So in a nutshell, Cape Town was designed to facilitate repossession of an aircraft. But now the lessors, the creditors, they are not seeking for repossession. They are trying other routes because they know if they repossess, they will have no places to deploy the aircraft, and they are also facing challenges where airlines are simply wishing to reject aircraft, such as LATAM did.
Are you hearing Thomas?
No, I don't hear Thomas.
Okay, Thomas, I think we are not hearing to you. Or is the mic?
Yeah, we still lost your audio, Thomas.
Well, this is Flores. I'm not an expert at reading Tomas, but I do recall we had a bit of a script and then some different questions routing to different people. And if I remember it correctly, I think the next topic was to talk about Aeromexico a little bit. So maybe we can all sort of panelists follow our own self-guiding here and see what we can do. So I'll talk now that we've had a good call it legal basis around different issues in these Chapter 11 cases. Let's take a quick financial look at Aeromexico to set the stage for some of the rest of the topics this afternoon. Aeromexico is Mexico's national carrier. They filed for Chapter 11 on June 30th. Potpourri of first day motions. I don't want to say that they took the playbook from Avianca and LATAM, but they all have very similar profiles. These three cases, lots of aircraft, lots of long haul routes, not a lot of cash and very little government support, which we've already talked about. I think there's a little bit of distinction with Aeromexico relative to some of the other carriers, a little bit smaller in size than Avianca and about a third of the size of LATAM. They have 120 planes, 90 of them leased, 30 of them unencumbered. Aeromexico filed with $160 million of cash on their filing date, which many people think is definitely not enough cash and a little bit late for a filing. However, they are reporting some cash burns for the next quarter of only $20 million, which if they can achieve that would be great. But their debtor in possession financing, like Melissa commented, is also going to be coming shortly. And they're indicated that they're looking at both a single tranche and a dual tranche, which is similar to what was described regarding the LATAM dip, where I also think it'll be a dual tranche with some type of investor-backed portion, some type of equity-backed portion, followed by a bigger tranche coming from the broader market. Melissa mentioned some lease rejections in Avianca and LATAM. Aeromexico also did not skip out on their opportunity to immediately reject their aircraft. So of their 120 planes, they put a motion on the docket shortly to reject 20. They're rejecting 10 single aisle 737s and 10 Embraers, which are the regional jets, along with a few leased engines. I think Aeromexico is doing a little bit better these days. It's all sort of relative when I set the stage of how difficult it is for airlines, but Aeromexico relative to LATAM and also Avianca benefits from the proximity to the United States. It benefits, I think, a little bit greater with its relationship with Delta. And so there's quite a bit of Mexico-U.S. flow in addition to the domestic Mexico air traffic, which, given the size of the country, folks do tend to move around a little bit more for essential business activity and other things. So they're doing, I think, a little bit better, all things considered, but they have a long way to go. And they have a long way to go. I don't think this case is going to be any more or less complex than LATAM or Avianca, but they have financing to finance their it's called the PDP, or that's the financing for your aircraft that are under construction by Boeing. They have a syndicated loan backed with Amex charges. They've got a potpourri of government financing, German financing, Exim Bank for the U.S., Canadian export loan. They have some Bundes financing, speaking of Brazil, for the Embraers. And on top of that, they have $230 million of local Mexico market issuances and a $400 million bond issued in the U.S. So that's a total of $2 billion. And all the airlines are doing are just trying to buy some time, buy some protection from creditors. Everyone thinks these cases are going to be longer in time, 18-month, 24-month cases for all three of these carriers. And that's about the amount of time that many people think, including the CEO of Delta on his earnings call comments last week, about a 2-year recovery. And so these Aeromexico, just like the rest, would like to hang on during Chapter 11, try and generate some cash flow, keep some creditors at bay, see if the market will recover, right size their operations, and then exit with some better multiples than they might get today. So that's sort of the backdrop on Aeromexico. Let's see if Thomas's audio is working again.
Thank you very much, Flores. Can you hear me now?
Yes, we can.
Yes.
Oh, wonderful. Technology is always, my biggest trick is to get out and come back, and then sometimes it works, so no, it did. Okay, let me go to the next topic, which is an issue about guarantors, which many times come up, and also in terms of suppliers. Let me start with Benjamin. What is the status of guarantors which have filed or which have not filed in Chile? What is the situation? How are suppliers reacting to the U.S. filing of LATAM, and so on? What are the issues you're encountering?
Yeah, and we had the opportunity to have a short talk about this with Melissa, but so far the guarantor itself does not apply for a Chapter 11 and it's not protected by a stay. I think general rules should apply here following what is happening in the US. Obviously, we have our own national rules about guarantors, and maybe it is important to consider them because, again, the recognition could not affect our public order. And the rules here is that, about the situation of the guarantors if they are not applying for a reorganization themselves, is that whether at the end, whether the creditor that has the credit against the guarantor voted or not in the reorganization plan, and that makes the difference basically. We don't know really what would happen if in the US there is some recognition I mean, not to collect debts against guarantors, but I think that would depend what happens in the US. So Melissa could tell us what would happen in the US, and then the effects will be in Chile.
Absolutely. Please.
In the United States, the automatic stay would not prevent a creditor from pursuing a guarantor. So if there's, say, for example, a guarantor of an aircraft lease, upon the filing, the lessor would be stayed from proceeding against the debtor, but not against the guarantors. There are situations where a guarantor could file an application with the bankruptcy court to seek an extension of the automatic stay so that it would apply to the guarantor, but that's a very high burden, very rare situation that would occur. and it wouldn't necessarily occur in a case of this magnitude. It occurs more likely in a smaller company where the ability for the guarantor to continue to operate a smaller operation is essential to the reorganization of the case. So here, the automatic stay would not prevent the pursuit of the guarantors.
Melissa, two quick questions about U.S. law. If there is a rejection or abandonment of an aircraft, these are breaches to the agreement. And of course, as breaches, there are damages. How would they be treated in a U.S. bankruptcy? These damages, which lessors or the lenders to the lessors or all these other stakeholders, which Flores described here. If they suffer damages, what remedy do they have?
So a lessor whose lease is rejected would have what we call in the United States a general unsecured claim for the remainder of the lease payments due under the lease. And that's the lowest priority claim in a Chapter 11 bankruptcy case, and oftentimes receives a distribution of pennies on the dollar. Likewise, a lender who has an aircraft who has a deficiency claim, because after they receive the aircraft back, it's the fair market value is less than what's owed on the loan, would also have a general unsecured claim. So that's again the lowest priority in the Chapter 11 case, and again see pennies on the dollar. There are other provisions in the lease agreement other than just the economic provisions of payment for the lease terms, such as claims arising from the condition of the equipment being returned, or sometimes even liquidated damages provisions. And generally, the U.S. courts will apply whatever law, state law applies to the contract to determine whether or not those provisions, those claims will survive. With respect to liquidated damages, at least one Southern District of New York case that's dealing with airline industries has found that they will not award liquidated damages as a claim if it is a penalty and it has no reasonable bearing to the actual default under the lease.
It's very interesting. We don't have a lot of time, although I have not received so far the questions, Crystal. I don't know if it's a technological glitch, but let me ask you a few more questions. What is the situation of the ticket holders? I think Benjamin already explained that there is one lawyer who had a ticket and who claimed that he would not be subject to the U.S. bankruptcy law. But how are the different countries dealing with the passengers that have bought these tickets and they cannot fly? What is the treatment which is given to them? Let's start with Benjamin now, and go quickly through the others. Okay.
Honestly, besides this this lawyer claiming in the file, we don't have really too much action on that on tickets. I think it's too new and too preliminary to have some conclusion on that. Probably consumers law will apply and probably will. I think probably there will be a conflict between that and the recognition of the foreign judgment, but I think it is too soon to say that. Yeah, honestly.
Let me ask Felipe quickly what has been done in Brazil with the ticket holders so far, and then we go to the other panelists.
So far in Brazil, there is a provisional measure which is to be approved and converted into law, which provides additional relief for the airlines, allowing the airlines to reimburse tickets for within a period of 12 months from the cancellation date. and there are some decisions by the aviation authority allowing airlines to not to apply the provisions that would be enforceable in the past in the normal situations, such as to flight delays and flight cancellations. So the government is sensible to it and wants also to provide some support with the airlines in order to avoid a lot of new claims with courts in Brazil for flight cancellations, flight delays, modifications, and so on.
Thank you. Jaime, anything in Colombia?
In Colombia, nothing of special regulation. So ticket holders in Colombia would, basically be considered unsecured creditors with no special priorities. And similar to what Benjamin was saying, they could file claims under consumer laws in Colombia, but again, with no special priority in an insolvency proceeding, they'll just be part of the universality of the unsecured creditors. So it's all subject to private contract.
My understanding is that in the US, 166 airlines, or maybe not, it's 167, have filed for Chapter 11 protection. Of these, I understand that 60% were successful. So the system has worked remarkably well for airlines in the US in terms of restructuring. Now I lost my train of thought. In Brazil, we've had 7 experiences of aircraft insolvencies, and practically all of them failed. The only one which had a small results was Varix Restructuring, because part of their fleet went to Gol, which is now one of the 3 leading aircraft carriers in Brazil. The issue here is that looking from a national interest, it seems that recognizing the US Chapter 11 proceeding is a useful tool to avoid disruption of the airline traffic and transportation services, especially considering the track record of Brazil and of the US. We have a bill in Congress now pending, which is number 6229, which is proposing to recognize the uniform law, the Uncitral uniform law for cross-border insolvencies. And I think they would be very useful, in my view, here in Brazil to affect that. Melissa, let me ask you, is the perception I have about let's say, about the usefulness and the practicalities and of the restructuring of US airlines warranted, or does the system not work as I imagine it does?
No, I believe your assessment is correct. I think it is warranted. I think there are many protections in addition to what we spoke of today that can come out through a Chapter 11 proceeding, such as one of the things that we talked about earlier in an earlier call is like critical vendor motions, where a Chapter 11 debtor can pay the claims of suppliers who are providing critical services to the debtor. And all of these protections, coupled with the ability to reject cumbersome leases and the ability to abandon property, really increase the ability for an airline company to organize in the US. So I think your perception is accurate.
Yeah, because looking at the macro situation, airlines don't really have assets, right? I mean, their aircraft are leased mainly. They don't belong to them. And the other asset are some old computers and some old worn uniforms. So there aren't really assets there, which most of the time, sometimes there's some equity interest in some of the aircraft, which were acquired through a finance lease, but which in the broader picture is not that relevant. So basically, creditors, they really have to rely on the restructuring of the company and future cash flows and future performance, and that's the thing. And it seems that the discipline of the, which Melissa described to us, of the DIP loans and the rejection of aircraft and the other measures which are effective in the US, and even recognizing critical suppliers and then certain administrative credits, which means credits which could be paid in spite of the automatic stay. It seems that they have a system which is well designed for aircraft failure. But I would like to hear our other panelists of what is their feeling, especially if comparing the US system to the system which is prevalent in their own countries. Should we start with you, Flores, then, talking about Mexico?
I actually think that's a better question for our attorneys who are day in and day out taking a look at the legal system. So I'll let them say a few words.
Yeah, I mean, the question is kind of moot, right? Because your countries recognize the US system. The issue is, what about the public order rules and what about the exceptions, consumer law exceptions, or the whole idea of the principal place of business? Should that prevail, or should a full recognition of the US filing prevail? Benjamin, what do you think?
Yeah, I think yeah, it's difficult to say, but I think the recognition will prevail. But we have to understand that, for example, the Uncitral rules for determining the main place of business, it has 12 factors, 12, so different or as different as where the places of the accounting books are located, where was the financing, where were the goods or the main operations, main place of the main bank that was the creditor of the debtor, etc. A jurisdiction that has control on the company. There are 12. I mean, if you read the guidelines on how to apply Uncitral rules, they have 12 different factors. So when you have so many factors to interpret, to give interpretation to a rule that talk about the main place of interest, I think at the end the decision is more, I'm afraid, more political, in the sense that you can apply as many factors as you want to apply. That's my honest opinion.
Thank you, Ben. Jaime.
Yeah, so in Colombia, I would expect that the recognition of the foreign process will always prevail, especially as it relates to airlines. And the situation in Colombia is that our transportation infrastructure relies, you can say, mainly on the operation of airlines. So, and that's why there has been such a sensitive discussion around Avianca on whether the government should or should not provide any financial aid, because without the main airline in Colombia, transportation may be substantially at risk within the country. So based on that, and given that we do have law 1116 that is based on Uncitral rules, our bet would be that the Colombian court, a bankruptcy court, which is the Superintendencia de Sociedades, will prioritize the sustainability of the operation moving forward. So to the extent that the US, as you were saying, the airline has little or no assets, the contracts, the main contracts and agreements that the airline, the Colombian, Avianca, and the other airlines have are governed by US law, by New York law, or some other jurisdiction, or English law. So to the extent that, for example, the Colombian court would have a bankruptcy proceeding in Colombia prevail, it would be excluding, the whole discussion on foreign agreements or agreements subject to foreign law, and that would probably bring a higher level of uncertainty of the sustainability of the operation of the airlines. So our bet is whatever guarantees the operation, the continuance of the operation the most, will probably be the course that the bankruptcy court in Colombia would take.
Thomas, we can't hear you again.
I don't think that Thomas is on anymore.
I can still see Thomas on the video, but there we go.
Now you can hear me. Yeah, I got some strange messages that I should close myself here because the internet is not very good. In any event, to finalize, we're 14 minutes over our allotted time, so I would ask for Felipe for his last words in conclusion of our webinar, and tell us a little bit how he sees the future of airlines, also from a Brazilian perspective.
So thank you, Thomas. Although it's still a very critical situation, it is important also to bear in mind and be aware of the news that are positive, such as the airline's slow recovery. Brazilian airlines are gradually reopen routes, and this pandemic has showed a lot of willingness between creditors and lessees and debtors to renegotiate its position and renegotiate their agreements and the way that they operate and they use aircraft. So it will definitely change from a financial perspective the industry forever, both in the private aviation and also in the commercial aviation. I believe that for Brazil, there is a lot of learning since the airlines are struggling and are trying to be creative and very innovative. So you have airlines such as LATAM filing for Chapter 11 in the US, which is new. You have other airlines looking for new forms and sources of financings, using new type of collateral. So it's also a moment for opportunity and for the airline to rethink its business model, but always to keep the idea for the overall protection for creditors, even if it comes a bit later than the expected 30 days that was the envisaged declaration by Brazil under the Cape Town Convention.
Thank you very much, Philip. So now I would ask each one of you to say a final comment, I want to thank you very much for this wonderful webinar and for the intervention and for the participation of each of you. should we go the same order which we started? You know, let's start with Flores, and then each of you, if you have some final words, please. For this webinar, I mean, the next one we can start all over again.
Thanks, Thomas. Thanks, all the panelists. Just to pick up on Felipe, you know, and a few last thoughts about the future of flying and aviation. I think we've talked about what's going on in the short term. So we've got the fleet rationalizations, the bankruptcy programs, the survival activities just to get through. In the medium term, and I'm referring to basically 6 months from now to 18 months from now, there's going to be an assessment of the new normal within the aviation industry. There's likely going to be even more insolvencies, particularly perhaps some U.S. insolvencies once government subsidies run out. There will also be mergers and acquisitions within the sector over the medium term. And, you know, at the end of the day, as has been mentioned here by a number of panelists, airline transportation is an important part of, you know, our world, our economies, just a form of transportation in Colombia and the country of Mexico as well. The movement of goods and services, it's really important. So in one way or another, you know, flying will return. In what shape or form, I think it's still to be determined and when. But at the end of the day, people want to travel. People are getting tired of being cooped up. They have an economic requirement to travel. Or they're just simply comfortable with the risks and are getting back out there. So that's a good thing in the short term, like Felipe was mentioned. But until corporate travel and long haul travel comes back in a relevant way, it's going to be difficult times for the major international carriers. And so we just get to sit back and see how these Chapter 11 cases of these 3 major Latin American airlines play out. So thanks, Thomas. Thanks, everyone.
Thank you. Benjamin?
Nothing really to add. I think you said all, Floris and Thomas and all the guys there. So nothing to add, just to remark that we are still in ongoing news, that insolvency procedures are already getting here, and probably more also in the US, and each day unfortunately we have more reorganization. So I think we are expecting how future Chapter 11s in the US will be recognized as well in Chile, and how we will deal with that. So thank you very much.
Jaime?
Yes, on my side, I think the next interesting chapter for these airlines, at least in our region, will be, the M&A potential wave, or I would say substantial changes in the industry generally. Because for example, in Colombia, you have low-cost airlines that have been initiating operations and have not suffered as much as the traditional airlines. You have also a government-owned airline, which is also announcing consolidation and expansion. So it's going to be interesting to see, where the industry, what's the direction of the industry, and whether or not there still can be more consolidation in the industry that we've seen for many years. But certainly, it's going to be a few years that are going to be very interesting.
Oh, I will just echo the comments that we made earlier, that the Chapter 11 process does appear to be working for the airline companies for the reasons we stated, with the debtor in possession financing and the ability to avail yourself of the protections under the code. But just as that's been working, the importance of it is, it's vital that it's recognized in other jurisdictions. Because if it's not, then other foreign creditors will be able to thwart the reorganization efforts in the United States, and then it will not be successful. So I think what we see in recognition in the next coming cases is going to be just as important as what we're seeing happening in the Southern District of New York. As they've been saying throughout this entire pandemic, we're in it together, so we got to get out of it together. And that goes for the airline industries as well.
Thank you. Felipe, anything else?
Just to thank you, the participants, and also to keep positive about the industry. It might be a slower recovery than we expected, but as Melissa pointed out correctly, we are all in this together. And as I always mention to clients, we will fly again. Our clients and our industry leaders will fly again, and this will bring us to a new era of air travel, and with a lot of learning and expertise from this pandemic.
Thank you. So thank you very much. Thank you for all those who assisted, who participated in our webinar. I hope you enjoyed it. And thank you, Meritas, both especially Crystal and Gemily, who are responsible for the success of this webinar. And so I wish you a very, very happy day now, and the next days also. And that we soon will be traveling all over the world again. Thank you.
Thank you.
Thank you.
Thank you, Thomas. Thank you for Meritas. Thank you for each of you for coming together with this great knowledge to share with everybody. And Thomas, thank you for helping us pull it together. Before we sign off, I just wanted to mention again that we will distribute a copy of this presentation and recording of the webinar, as well as everybody's contact details. Please do not hesitate to reach out to them directly if you have any further questions. And feel free to share the recording of the webinar with others that might find it of interest. So thank you for joining us, and thank you again for each of you for presenting today. I hope you have a great day.
Thank
Bye.
you all.
Thank you. Bye.
Thank you.
Have a nice day.
Bye.